Good evening, everybody. Thanks for being here. I'm Nate Eaton. This is Courtroom Insider from Arizona. Tonight, I am in Scottsdale, and my, oh my, oh my. What an interesting hearing this morning with Lori Vallow Daybell. All I can say is that buckle up for this trial because it is bound to be interesting. Somebody above me is making quite a bit of noise. I don't know if you can hear that. I'm going to go through it all today and also with you talk about what happened this morning at the trial in downtown Phoenix. Also, I'm on Lori's witness list. News to me. I'll talk about that here in just a moment. And also, I did some driving around the Phoenix area over the past day or so, going to some key spots that will play a role in this upcoming trial. We actually heard about them in the Idaho trials, but I actually want to show them to you as far as where Charles was shot, where Lori then went. One critical hour, we could call it, the day that Charles Vallow was shot. So we'll get to that. We'll also get to your questions. Before I forget, if you haven't subscribed to our YouTube channel, that would be awesome if you did. That is where we will be streaming Lori Vallow's trial coming up here in 3 weeks, less than 3 weeks. Well, jury selection is less than 3 weeks. So you can go to the YouTube channel, and I appreciate you following me wherever you're at. If you have a question, put it in the comments below, and I'll try to get to those a bit later here. So first, to set the stage for you, this trial is about Charles Vallow's murder that happened back in July of 2019. Lori is also, she's charged with conspiracy to commit that murder. She's also charged with conspiracy to commit the murder of Brandon Boudreaux, her former nephew-in-law. That trial has not yet been set. But we know as of after the hearing this morning that it's going to be relatively soon, and I'll get into that in a minute. So for this specific one, what we're doing right now is just Charles' case, just so we're clear on that. And this morning, Lori Vallow appeared in court, walking in. You could hear her coming down the little hallway with her shackles and her handcuffs, and her advisory attorney was there with her. And on behalf of the state, it was a lady named Trina Kay, and Judge Justin Bursky is the attorney. And there were several items on the agenda. The first thing that was talked about today is coverage with cameras, courtroom coverage. Lori had filed a motion a few weeks ago that she did not want court TV in the courtroom. The judge heard from Court TV's attorney, who basically proposed that they would be the pool camera, meaning all of the media outlets, there would be one camera in there, and all of the media outlets would use that camera as feed. And the judge said that will likely be on a 1 to 2 minute delay. So it won't be live, but it will be pretty close to live, which is awesome. As you know, sometimes you have to hold all the footage till the end of the day in some trials, in some states. Sometimes you have to wait 30 minutes. But it sounds like the judge will allow live streaming with a bit of a delay. And he's going to lay out all the order, all the rules in an order that he says he will release a bit later. So good news for the First Amendment, good news for us, for you being able to watch the trial. We will be able to provide that for you on East Idaho News. However, there will be no coverage of the jury selection. And so the judge kind of explained how the procedure is going to work. What he's going to do is let me just go through this. On potential jurors, around 200 of them, will be sent an e-questionnaire next week, and or at the end of the month, and they will fill them out, and Lori Vallow Daybell's name will be mentioned in those questionnaires. The judge said normally he doesn't mention a name, but because this is so high profile, he wants to mention the name. And then out of those 200, those that advance will be called down to the courthouse, and they will do questioning on April 1st, 2nd, and 3rd. And it looks like opening statements will begin on April the 7th. So that first week of March/April will be happening with the jury selection. Okay. The other interesting thing to talk about is, so that we talked about the jury selection, we talked about the cameras. We talked about, well, I do want to mention also Kay Woodcock she was joined via Zoom for the hearing, and so did Brandon Boudreau. I want to mention they were there, but on Zoom cameras, which is a private feed. You're not allowed to join that feed unless you're part of the case. Okay, we talked about cameras. Daybell, Lori Vallow did mention, let me just play what she said about having cameras in the courtroom.
We want to make sure that the camera's not going to be zooming in at any level to get to our notes and the things that are going to be on the table. I also previously, what has happened before is that they just have the camera on my face the entire trial. So I think when the judge is speaking, the judge needs to be on the camera. When the state is speaking, they need to be on camera. If we can add that to the order, I think.
All right, well, my draft already includes that there'll be no zooming in on counsel table, anything on counsel table, or anything being handled, notes or that sort of thing being handled by any of the parties or the attorneys.
The prosecutor did mention, there was talk about the courtroom. Now, this is a small courtroom. I think we counted there were 36 seats total in the courtroom. It's small, and it sounds like this is where the judge is going to hold the trial. The prosecutor had asked to maybe move it to a larger courtroom with some rooms for witnesses, and the judge said that that's not going to happen. So please don't come. I say that with so much love. Please watch from home, because there's only 36 seats, and, those are going to be taken. That includes victims' families, and that includes like law enforcement. I mean, you saw in Idaho, there were some days there would be 15 to 20 people that were family members and victims, and then the remaining seats were for the public. There's no special media seating in this one either. So if you can, watch from home and watch Courtroom Insider every night at 7 o'clock Mountain, because that's what we'll be doing. The prosecutor was a little concerned. She did mention she was worried that the witnesses would be mingling with the media or the jurors. The jurors might be out. And so the judge said they will take some protective actions against that. But it sounds like this room is going to be the trial is going to be in this very small courtroom. Sounds like trial will be held every day, except the prosecution is requesting a half day on April 24th. The judge did ask if autopsy or crime scene photos will be shown in the trial, and the prosecution said yes, both will be shown. And because of that, the judge is going to mention that in the questionnaire. So if jurors have a problem with that, they know ahead of time to be prepared for that. Lori was taking notes with a short little pencil and one of those little purple erasers on top that you stick on top of your pencil. She had a yellow notepad. Her hair was like kind of in a ponytail. She was smiley. She was chatting with her advisory attorney, whatnot. Typical Lori behaviors. She did get a little feisty talking about some evidence that she says has not been turned over to her. Video footage of her and Tylee and Melanie Gibb, I believe, being questioned. And here is that exchange.
The body cams were turned over, and they're in like 12-minute increments. There's like 4 different body cams. This was a full 2-hour video that was released by Gilbert Police to the public, and it's online. So I would like that video of the interrogation room, the full 2-hour one, to be turned over to the defense.
All right, so do you know what that is?
Your Honor, based upon the defendant's reply, she's requesting a video interview from the 31st. Those are on body cam and were turned over to the defense. We have requested everything from, I think that one was from actually the Gilbert Police Department. A lot of these overlap. So I am not sure what the defendant is.
Who was the person being interviewed, and you said the 2-hour interrogation that Gilbert released?
So it's myself and my daughter, Tylee Ryan, and Melanie Gibb.
And is that in an interrogation type room?
Yeah, it was at the Gilbert Police Station, and I didn't realize we were being filmed that whole time. I didn't know we were being filmed, but we were being filmed in that room.
And are you familiar with a video in a room?
Yes, that's what we have disclosed, is an interview of, it is
And you're saying you don't have it?
defendant, her daughter, and another.
And you're saying you haven't gotten that?
They have given 4 about 12-minute body cam videos of the policemen's body cams that were in the room with us, and they go in and out of the room at different times. So there's different body cams. They're all mixed up. It's not the full entire one, and the full entire, my understanding is that the full entire 2-hour interrogation room video from the ceiling is available online, but I don't have it in Discovery.
Have you seen this, or someone told you that there's this video?
My mitigator showed me part of that video, yes, with my previous team. That's how I know about it, otherwise I wouldn't know about it. She said, do you know this is online? I didn't have any idea.
And you're sure it's the Gilbert PD on that date?
Correct.
All right, I'll ask the state to follow up with Gilbert on that.
So the interesting thing to me is that, well, first of all, the state said they would go back and check their files and be sure she gets a copy of that video. But the interesting thing to me is when the judge asked Lori, how do you know the video's out there? And she responds, my prior defense team showed it to me. So then wouldn't they have it? Unless, I guess they could pull it up on YouTube or something, pull it up on a computer. Okay, now we're getting into a few motions in limine about Alex Cox's statements and Tylee Ryan's statements the day that Charles was shot. I'm going to be honest, I wasn't quite sure what Lori was arguing. And I don't know if many people were, but there was some back and forth with the judge. Lori, it sounds like, does not want these video interviews admitted into court, that these statements that Alex made the day that Charles died and Tylee made. I don't know how to further explain it other than to just play it.
Let me ask the defendant, generally any hearsay is defined as any out-of-court statement offered for the truth of the matter asserted. The state is referencing what are definitely out-of-court statements. Obviously, there's some exceptions to the hearsay rule, and there are other things that are characterized as non-hearsay. So how do you think, let's first talk about Alex Cox. How do you think the statements fit into either one of those exceptions or non-hearsay?
I feel like the state is blanketing that whole thing, and obviously it's like a case-by-case basis, right, on these statements. So there is the police interview of Alex Cox that I do not think falls under hearsay.
Why not?
Why does it not fall under hearsay?
Yeah.
Because we're not using it for the truth of the matter asserted. We're using it in corroboration of the circumstances. Everyone came in and told their same story that corroborates different facts in there, not for the whole truth of the matter.
Aren't you arguing that what he said was true?
I can't say whether another person says that it's true or not, but I'm saying what he said and what my daughter said and what I said in those 3 police interviews determined what the police said, how the police acted, what they did after that, their next steps, how they treated the entire case like it was self-defense. All of those are relevant to the defense that it was self-defense. So, yes, I think they're for that purpose. But I also think that Alex's statements also have a lot of the exceptions apply. 803, 804, there's a lot of exceptions that also apply to some of his statements and not all of his statements.
Such as what? Which statements do you think they apply to?
Specifically his statements made on body cam to police in the driveway, specifically his...
I don't know what the statements are, so that's what I'm asking. What specific statements do you think are allowed to come in under the rules of evidence?
I think under 8031, the present sense impression is his statements made to police officers at the house.
A present sense impression is where you're actually observing something and you're talking about it as you see it happen. So isn't he saying, again, I don't know what the statements are, but is he saying what happened prior? Or is he saying
Yes,
something
prior.
that he's, okay,
Correct,
so it's not a
prior.
present sense impression.
Okay.
What else?
Then I think it falls under 803.2, excited utterance. He was under the stress of the whole situation when he made those statements.
What was his demeanor when he made those statements?
Upset.
What's the specific statement?
I shot my brother-in-law in self-defense. I got hit in the head with a bat. There was an altercation. I don't know what all the statements are, but
How long after the incident did he make these statements?
immediately after, as far as I know.
Well, immediately to some people means 2 seconds, to other people it means 30 minutes. Tell me what immediately means to you.
As soon as the police arrived.
I don't know what, did they arrive 30 minutes after the incident? 10 minutes, an hour?
I was not there. I do not know what time they arrived.
All right. Let me, so you're asserting excited utterance, some of these statements come in, what else?
8033, the mental, emotional, and physical condition, because it shows his state of mind, which was scared at the time.
Any others?
Yes. 8035B, the recorded recollection. I know that in the state's reply to my response, they did not think that 805 applied because A, B, and C, but I did not see an and after A, so my assumption was that B and C, since there's an and after B, were what needed to be put together. So B was made or adopted by this witness when the matter was fresh in the witness's memory and accurately reflects the witness's knowledge. So I felt like 803B5B, the recorded recollection of his police interview and the body cam footage, applies under that exception.
All right. Generally, 8035 is a recorded recollection, meaning it's something they wrote down, or maybe they recorded their voice saying something. Let me ask the state to respond. We're just talking about the Alex Cox statements.
Your Honor,
Maybe I should start with,
Yeah.
does the state intend on introducing any statements from Alex Cox?
Your Honor, I haven't decided if we will at this point. I can say with 100% certainty, we will not be admitting his interview by police that was done at after 10 o'clock in the morning. We don't,
Are you referencing what time he was interviewed versus the time of the incident?
let me say it this way. So the state has laid out in its motion the timeline. So that is actually in our motion. We show that when
8:30 a.m.
is when the
roughly.
911 call was made. So we have soon after that, the police arrived and there's body cam video from that interview. Then Alex Cox is later brought to the police station and there is a in-depth interview with detectives at a little after 10 o'clock in the morning.
So you may or may not be attempting to introduce statements at or around the time that the police responded?
Correct, Your Honor. If we do, those would be brought in as co-conspirator statements against a party interest. So obviously the state can bring in statements that are hearsay against a party.
Right. But I guess, is the state intending on introducing any statements of Tylee?
No, Your Honor. Eileen made no statements at the scene other than giving her general biographical information on body cam. Her entire statements were made at the police station, again, after 10 in the morning.
All right. So on your response as it relates to Tylee, you say, again, present sense impression. I don't think it's a present sense impression. You also argue excited utterance. What else?
8033, which is mental, emotional, and physical condition with the same thing, her state of mind, then being scared. And also 8043, statement against interest. They use that statement in the indictment where Tylee says that Charles says, if you hit me with that bat, you're going to jail. That's the part where she's nervous in her interview saying she's scared to tell the police that she's the one that brought in the bat. So state of mind and the statement against interest both apply to Tylee's
All right.
police interview.
All right, anything else? Does the state want to be heard further on that?
Your Honor, the only further thing I think that the state will bring in is that obviously the defendant has been found guilty of killing both Tylee, other individuals, but in this case, the defendant cannot benefit from killing a witness and then later try to bring in their statements for their benefit. So in addition to none of her statements being admissible under the rules of evidence, as any of the exceptions that the defendant has done, we also believe that it would be improper for her to be allowed to bring them in under that theory.
In other words, there's been a judicial finding that the reason Tylee's unavailable as a witness is because of the defendant's actions.
Correct, Your Honor. There has been a jury trial and she has been convicted of that.
Yeah, Tylee won't be there to take the witness stand. So, interesting point there made from the prosecution. A couple of other things were discussed, including the prosecution wants Lori's handprints and fingerprints taken and photos taken of her, which they'll probably do next week. He said that they put it like in a database to see if if the person is connected to another crime anywhere in the state. So we'll see if anything comes of that. She didn't necessarily object to it, but we then transitioned into scheduling about Brandon Boudreaux's trial, which sounds like it's going to happen pretty quick. Now, Lori, well, actually, let me just play this part too, where she is arguing about the scheduling of it. She says her last legal date for her rights to not be violated, they have to start the trial by May 11th, but the judge has an interesting comeback. So here's what happened with that.
Your Honor, I'd like to remind the court that the last day is May 11th.
Well, I'll probably exclude some time based on the fact that you can't do two trials at once.
The state could combine the trials and do two trials at once, but they don't want to do two trials at once, so it really violates my speedy trial rights if they do not give me a speedy trial by May 11th for both cases. Not to mention that they did combine all the discovery into one case. They didn't give me two different separate discoveries for two different cases, which would be much more convenient considering the voluminous amount of discovery that they piled onto us.
Does the state want to combine both cases?
Your Honor, if the court gave us a little time to work it out and the defendant wants to join them, I mean, obviously,
I don't know that.
the normal defense attorney, and I don't mean that in any way, normally they would be severed.
Severed because you
Due
don't
to-
want one jury to know about the other
Correct.
two separate charges and have a harmful rub-off effect of the evidence in one case affecting the evidence in another case.
Correct, Your Honor. That's why they were filed separately. But if the defendant wants them together, the state would have to request this be pushed back slightly so that we could then get all the witnesses for that trial together, since they were not subpoenaed for this trial. But if that's what the defendant wants to join them, and she understands that prejudice and that she's then going to be waiving that prejudice with that, then the state is certainly willing to do that. But we would then have to request to have that trial, or this trial date moved back to allow us to get the other witnesses lined up.
that's not what I was saying, to combine them. I'm just saying, give me my second trial by May 11th. So the court can figure that out.
All right, well, I'm going to waive some time on that second trial over the defendant's objection. Primarily, again, the defendant can't try both cases at the same time. Secondly, I'm not sure how much actual prejudice there is with a time violation, in the sense that you wouldn't be released from custody anyway. And thirdly, the rule for time violations under Rule 8, I think it's 8.6, is that any violation should be a dismissal without prejudice unless there's an actual prejudice shown, in which case the state could just refile the charge. Regardless, I think some time is warranted to be excluded because primarily you can't try two cases at once. What if we set a start date for May 12th? I realize that's could potentially be a quick turnaround, but again, I don't think this case is going to take 6 weeks.
Your Honor,
We can adjust that as necessary.
I, again, am going to ask for a longer time. I believe this will go through the beginning of May, and to have the state try to get those witnesses lined up and subpoenaed while in trial, I don't believe is.
Well, if I push it out any further, the parties need to be aware that I won't be trying the case. I don't think I would be anyway. I'm rotating at the end of June. And given some of the trainings I have to attend in June, I don't think we can get it done.
So we wait to see when that trial will happen. Sounds like it will be done by this summer, especially if the judge is off the case. So that'll be interesting if these trials are done back to back, and we could have this all wrapped up here in the matter of a few months. A couple of other minor things that came up. Lori asked during the trial where she'll stand, how she can get about. She said without having to wear this leg thing and a shock vest, she will stick to her table, but she can go to the podium when she's questioning. And if she needs to hand a witness an exhibit, her advisory counsel will do that. Excuse me. So she won't actually go hand the exhibit. The advisory counsel will do that. And that was today. The hearing was about an hour. You can go watch the whole thing on our YouTube channel. If you're into this story, I would advise that you should, because it was quite an interesting hearing. There will be another hearing next Tuesday, the 18th, that is apparently going to be quite short. And then the jury selection begins March 31st. And again, I'll be here for that, starting it off, and plan to be here every day during Charles's trial, and then we'll see if it goes into the next trial. I think the bottom line takeaway, how long is this trial going to be? Prosecution was saying we now need 6 weeks. They said we originally told you 2 or 3 when Lori Vallow had attorneys, but now that she's her own attorney, we actually need 6. The judge seemed to say that was a little much time. He seems to think it might be over in a month. And it all depends on, how Lori plans to question witnesses, things like that. And speaking of witnesses, you're looking at one, potentially. I hope not. I'll talk about that in just a sec. Before I get to that, I want to show you kind of a little video that I put together. The 1 hour of time, the day Charles Vallow was shot. I put together a timeline, and I actually drove to the locations from the house where he was shot, Lori's activities in that one critical hour back in July of 2019. I had never been to the home where Charles was shot. I didn't go knock on the door because somebody lives there now, but let me just show you the morning. Now, leading up to this, remember, Charles was concerned for Lori's health. He had been consulting with Adam Cox, who is going to be a witness in this case, in this trial. He had been consulting with him about Lori's mental health, and there was some sort of intervention. It sounded like the two were going to come together to get Lori help, and she seemed to know that was coming. She had told Alex, I need you close to me. I need you here. Alex canceled a trip, I believe, to Utah to stay there and go spend the night excuse me, go spend the night at Lori's house. So here is a video of Lori's movements that morning in July of 2019. This is the home behind me where Charles Vallow was shot and killed back in July of 2019. Beautiful house in a nice neighborhood in Chandler. At 7:33 that morning, Charles texted Lori, and then police say that his device was here at the house at 7:50. So 17 minutes later, his device was here at the house. And then for nearly 40 minutes, the device left the home. It was not here. And I'm going to take you kind of on a drive to show you the movements, according to police, that Lori Vallow went on with Charles Vallow's device, allegedly that morning, where that device ended up before it ended up back here at the house. Now at 7:52 that morning, there was a voice call between Alex and Lori. We don't know what was discussed during that call. It seemed to be relatively short because Lori stopped at a fast food restaurant. 2 minutes after that phone call, Lori went through the drive-thru here at this Burger King around 7:54 a.m. Charles's device was pinged here at the restaurant around 7:55 a.m. So they were here for just a few minutes. Lori ordered some chicken nuggets, some chicken fries, according to a receipt that we have, some Sprite, and a bottle of water. Think about it. While she's here getting that food, back at the house, about 5-6 minutes away, according to my driving records, Charles was dying, and Alex was there with him. Lori was here with Tylee and JJ, and then they left the fast food restaurant and did one more stop before taking JJ to school. Charles's device arrived at Walgreens at 8:16 in the morning. Surveillance footage captured Lori purchasing a pair of flip-flops. She was here for about 4 minutes. She then left the Walgreens around 8:20 in the morning. Charles's device arrives here at JJ's school at 8:32. 4 minutes later, at 8:36, that's when Alex Cox, back at the house, calls 911 to report that he has shot his brother-in-law.
I'm in police in an ambulance.
What's the emergency there?
I got in a fight with my brother-in-law and I shot him in self-defense.
Okay, let me get the medics on the phone. And is he hurt or is he alive or?
Yeah, there's blood. He's not moving.
How long ago did this happen?
A couple of minutes.
And at 8:49, the device ended up back here at the house. Of course, we have seen that police body camera footage with Lori Vallow talking to the officers, with Alex Cox on the side of the road dabbing his head, saying he had been hit with a baseball bat. And then Lori and Alex and Tylee were taken to the police station for questioning. And here we are 5 years later, awaiting Lori Vallow's trial. I hope that kind of gives you an idea of where these things were happening. I drove that whole route in, well, I stopped, of course, to get video, but you could probably drive that whole route in 20 minutes. That was in the afternoon when I shot it. This was in the morning. There may have been more traffic out, but the big thing to me was how long Alex Cox was at the home as Charles lay dying. And that was brought up this morning, that clip I showed you earlier, that was brought up this morning when the judge was trying to pin Lori down as far as the timeline and everything. So that again, can show you where these things took place and what we can expect with the trial. Okay, let me talk about this witness list that Lori Vallow filed just a few days ago. This is a defendant's supplemental rule notice of defenses and disclosure. The defendant submits the following supplemental disclosure pursuant to Arizona Criminal Rule 15.2. The defense notices the following defenses. 1, insufficiency of the state's evidence. This is going to be her defense, apparently. Self-defense, defense of others, third party at fault, mere presence, and procedural. I don't know what mere presence defense is, but that is her defense. The defense notices the following witnesses. 1, the defendant. Sounds like Lori wants to be a witness in her own trial. 2, any and all individuals, including but not limited to victim assistance caseworkers and or volunteers who have spoken with any witness in this case. Heads up. That's a lot of people, but she doesn't list them. All witness listed in the state's Rule 15.1 disclosure, as well as in any supplemental witness disclosure filing. Also, the custodian of records for any and all exhibits. And then me, Nate Eaton. Vicea Ituahua, I'm so sorry, Vicea, if you're watching and I said your name wrong. She is Lori Vallow's, or Tylee's, one of her really good friends. Gabriel Bonilla, I don't know who that is. Joseph Ponsgratz, I don't know who that is. Ashlyn Rind, she took the stand in the trial in Idaho. That was Tylee's best friend. Barry Cox, Lori's father. Zach Cox, Charles's son. Adam Cox, her brother. Janice Cox, her mom. Summer Shiflett, by the way, her last name is Shiflett, not Shislett, her sister, and Brandon Boudreau. The defense notices the following documents, photographs, and other tangible objects that the defense intends to use at trial. Any item disclosed by the state, insufficiency of state's evidence. I don't know what that is. Disclosure remains ongoing. Miss Daybell will supplement as necessary as this information becomes known to Miss Daybell. Why am I on the witness list? I have no idea. I didn't know I was. Justin Lum from Fox 10 in Phoenix let me know the other day, and then I got this document. But I have not been served a subpoena. And until I'm served a subpoena, from what I've been told by attorneys, I'm fine. Now, I'm in Arizona for another little bit of time, and then I'm flying home tonight to Idaho. If Lori, from the way I understand it, Lori would need to issue a subpoena in Arizona for me, and then Idaho would need to recognize the subpoena, and then I would get served the subpoena in Idaho, and at that point, I would get my attorney involved to quash the subpoena. Sadly, I have been subpoenaed before. John Pryor subpoenaed me, and it cost us a lot of money, East Idaho News, a lot of money to get it quashed. Adam Cox has said publicly he's going to be a witness, but I've spoken with a couple of others on here who had no idea that they were going to be a witness, and they haven't been served with a subpoena also. And this trial starts in 2.5 weeks, 3 weeks. So you'd think I would have a subpoena by now. But why does she want me subpoenaed? I have no idea. I have no idea. I did think, I've been thinking about this interview that many of you have said, if I could interview Lori. You think I should ask her to interview me? Ask her what she wants out of me? I don't know. Share your thoughts. That could be a really bad idea. Or it could be an interesting idea, as far as what she says. So there's where the witness list stands for Lori Vallow Daybell. Okay, I now have some questions from you that I want to go through. Lots of questions after last night. We talked about reaction to Lori Vallow's Keith Morrison interview on Dateline. And somebody asked about the ratings, and the ratings were huge. They were good. In fact, it was, I think, Dateline's highest watch episode this season other than their premiere. So thank you to everybody who watched. My question sheet, Peggy, our comment moderator, has done a great job gathering all these from you guys. So let me open this up. Here we go. Sarah, Lori named you as a witness. Tell us everything. Well, I think I just told you. I wish I had more to add. Why she may have done it, I don't know. There is the thought that if witnesses can't be in the courtroom covering that or observing witness testimony, and because it might affect their testimony. I don't know if that's why she would have done this, but I'm still going to cover it, and I don't know what she would want to ask me, but that's really all I know, and I don't want to comment too much on it. Karen asked, do you think Keith really thinks Lori is intelligent, or was he just being politically correct? No, I think he really does. And I think she is a little bit of intelligent. Look at her. Look at her in court today. Intelligent can mean many different things to many different people, and it can be varied degrees of intelligence, as you all know. But she has some smarts about her. She definitely is not dumb. Candace says, is Lori trying to taint the jury with her nonsense-ridden interview? Perhaps. Yeah, it's perhaps that she wants to have them see her. I don't know the timing. I think it's more that she felt the need to get out her version of events, or her truth. rather than, not taint a jury or whatnot. Jennifer, can you please explain why there are no charges brought against Lori's niece? I'm assuming you mean Melanie Pawlowski. I don't know. I'm not the attorney. Obviously, the prosecutor, if they had felt there was enough evidence there or that enough wrongdoing had been done, that they would have charged her. And it's possible they could still charge her, but it's, we're 4 or 5 years down the road from this. You would have think she would have been charged by now. And I don't know what those charges would have been. There could have been conspiracy. I don't know if there was evidence out there. From all we have seen, the evidence dumps, the data dumps and everything, there haven't been any text messages that I've seen that have been publicly released showing Melanie conspiring with Lori and Alex over the death of Charles or Brandon, as far as I know. But we'll see what that comes out. But as of now, no, she has not been charged. Joy, does Lori regret anything she's ever done? That is the question to ask Lori. Oh, that's a good question, Joy. Yeah. If I get to ask her, I will ask her, do you regret anything you've done? Do you think Lori was allowed to watch Dateline? From Michelle. Well, I've been told that she has not watched it yet. And she was asking questions about how to watch it and how to get a copy of it because she couldn't watch it when it aired, and they obviously are restricted on internet and whatnot in there. So I've been told that her legal team may be showing it to her down the line. Lelani, sorry. Is it true that Lori can't be medicated and represent herself at trial? If that's the case, does that pose a potential problem later on? I don't know what you mean. She could be medicated. Well, I don't know if they can force her to take medication. She's not taking any medication. And if she was, I don't know if it could present a problem or not. I don't know. That's a good question. The police were called when both Tammy and Charles were killed. This is from Jeff. Why on earth didn't they get called when Lori found her kids dead, according to her? Very good point, Jeff. Thank you. I don't know. Vicky, do you think Dateline had planned on presenting a different way because of Lori's rambling? It had to be presented differently? Perhaps. I don't think they went in there with a set narrative. Normally how these work, as a journalist, we go and we do the interviews with whoever, with the people. And sometimes if it's like with the president or a congressman or a celebrity, you might agree with their people beforehand to say, we're going to do this 90 minutes live, or we're going to do this 90 minutes on tape with very little edits. I will always let someone know when I edit them or before the interview that we're going to edit this down into like a package, which is a short condensed version, or air it pretty much unedited raw. I think they went into that interview trying to get as much out of Lori as they could that would make sense, but also not just give her a platform to spew whatever she wants, because that could be irresponsible. So that was the balance they had to do. And, Keith didn't just want to give her a platform to just say whatever. And so that's why it was edited, and you didn't see as much of Lori as you wanted. I do think that, as you're doing these interviews, you're kind of thinking in your head, okay, that's news, this is news. You're trying to put it together. Marcy, did Lori mention JJ at all while with Keith? I imagine that she did, but I don't think we saw anything about that. But I'll have to ask Keith about the extent of the JJ talk and the Chad. I know many of you wanted to say, did they talk about Chad? I know they talked about Chad, but I don't know how in depth it got. Brian says, isn't Lori already locked up for life? What's the point of visiting a second trial? Great question, Brian. She is locked up for life in Idaho. These are different victims. Charles is a victim and Brandon was a victim. And on behalf of them, the justice could be served on their behalf in Arizona. So that's why. Kitty, we want to see you revisit Lori 30 years from now and interview her so we can see if she realized she's not a goddess and was never on a mission. Would you want to do that? Yeah, I would. If she's alive in 30 years, she probably will be. 30 years, I'll be in my 70s. Sure, I'll be old. Sarah, have you ever interviewed Colby? I've spoken with Colby, and I would love to interview Colby. I hope that comes down the line. Shonda, I heard the Douglas family was shell-shocked by this interview. The first they heard was when it was advertised. Do you know how they are doing? I talk with them regularly, and they didn't know it was coming. A lot of people didn't know it was coming. I think they're doing okay. I have repeatedly said that I told them I want to get down to Springville to visit with them soon, probably after these trials in Arizona. Do you still have a sound clip of Keith saying loin fire? Tell us you do, Chelsea asks. I probably do, but I don't have it handy, or I'd play it for you. I tried to go find it a couple of weeks ago, and I have it somewhere. I just don't know where. Is Lori allowed to talk to Chad? No, she's not. There could be a way to get around it, I would imagine. Like if I called Lori and then I called Chad on the other line, I could put the phones together, but all of that is monitored, and you could lose restrictions if you violate the rules. Can Chad be called as a witness? Glenn says. I guess potentially he could. He's not on Lori's witness list, and I would be shocked if the prosecutors called him. And many of you have asked, why hasn't he been charged? In Arizona, the prosecutors have said they just don't think they have enough to convict. Is Lori allowed to question witnesses? Yes, Tina. I mentioned that a bit earlier. I know before your question came in before that, but yeah, she can. She can. Rosanna says, "Will you please interview Chad?" I'd love to interview Chad, and we'll see if he responds to me. But as of now, he has not. Remind us the day the trial starts in Arizona for Lori. Jury selection starts the 31st. Sounds like opening statements will be April 7th, the following Monday. Is there a full, without edit, way to see the interview between Keith and Lori? That's from Wendy. There is not now. Dateline has not released the raw footage. I don't think they would, but if they do, we'll talk about it for sure. Who on earth's putting money on Lori's books? Well, I don't know. I do know that some people that really don't know her and have never met her are. Some of you in public, anybody could put money on her books. People sometimes get fascinated by communicating with inmates, and they're doing it. I have not sent her any money. The only money I've sent her is for her to respond to my messages, and she's used that money for other people. And she has responded to me too. But not. Most of that money I think has gone to other people. Judy asks if I interviewed Charles's sons. I have. No, I have not. I've talked to them, but I haven't interviewed them. I'd love to. They're wonderful, wonderful guys. What happened if Lori asks for attorneys during the trial? She can, and her advisory attorneys will then become the chairs, the heads, and then that's how it will be. She can't go back and forth. If she wants attorneys, she gets them, and it stays that way. Where are Chad's kids now from Kokomo? They're still, from as far as I understand, doing what they're doing. The ones that were living in the home have moved elsewhere, and they're just living their lives. We know Lori loves Chad. Is the feeling mutual? That's a good question. I don't know. I wish I knew. And if I get a chance to talk to Chad, I'm sure he'd say yes. But I don't know if he's moved on. It's be fascinating to find out. Is Melanie Gibb on the witness list? Not for Lori's. The state has not published a witness list. In Idaho, they kept that quiet. They kept it sealed until the trial was over. So it's possible that the prosecution could call her. Do you think Chad will divorce Lori? No, I don't think so. Maybe. I don't know what the point would be, but perhaps. Since Lori is her own attorney, can she have professional services like hair and makeup? No, I don't think so. She'd have to pay for that. She can, from as far as I know, get some professional clothing, but she can't pay to. She doesn't have any money, and the state's not going to pay to have someone come in and do her hair and makeup. If you've watched her though, she always does her hair and makeup. Every hearing, she's had her hair done and her makeup. Some days better than others. She was a hairdresser, so she knows how to do her hair. Will you interview Melanie Gibb again? I'd love to, if Melanie Gibb wants to talk. I think she's kind of, moved on with her life, or at least tried to remain kind of in the shadows. Have you heard if Chad's son could be charged with perjury? Sandy said. Sandy asks, he could, I guess, if he lied on the stand. I'm not saying he did, but if he did, he could. It would have to happen in Ada County where the actual alleged perjury took place. I'm not saying he perjured himself. I don't know if it would be worth it for them to pursue it. I would be a little surprised if it happened, but you never know. Do you think Melanie Gibb being interviewed by Lori on the stand would be problematic? Be interesting, that's for sure. Same with Lori questioning Kay Woodcock and other witnesses that will be called, the detectives. If this morning's indication is any sign, she seemed indignant this morning, not as sweet. And you could see a variety of emotions from her, I imagine, during the trial, where she's heated one day and more consoled the next. But my, oh my. Out of all the trials, this could be the one to watch. I mean, the other two were fascinating too. Okay, I have to quit talking and I have to go catch an airplane. So thank you very much for watching. If you haven't subscribed to YouTube, please do. Also, Facebook. My people at East Idaho News are like, remind people to do that. And don't forget, I almost forgot, Thursday, Marcia Clark's going to be here from the OJ case. Fascinating interview. I did it a few days ago. She's a wonderful human being. We talked all about her new book. We talked a little bit about OJ, what it's like being a woman as a prosecutor. That's kind of what this new book is about. It's a true crime story from decades ago that she's researched and dug into, and it's just a really interesting book. Thursday night, 7 o'clock, Courtroom Insider. And then next, I'll keep you posted. I don't know if we'll do one next Tuesday because that hearing's supposed to be really short. But there's going to be some filings coming in the next few days. And if there's, I might just pop on here and talk with you. But here's where you can find me. Twitter, X, I should say, Facebook, and Instagram, and also on YouTube. Appreciate y'all watching. Really, really do. I mean it. I got to meet a few people this morning at the court who have been watching, so thank you very much for watching. It keeps me employed. It really does. I get to do something that I love. So before my plane leaves me in Arizona, I'm going to go to the airport. Have a great night. Thanks for watching. See you next time.